Hello everyone, I am Shubham Jain. I am a final year law student at National Law University, Jodhpur. Today I'll be discussing the concepts of joint liability, vicarious liability, strict liability and absolute liability. The concept of joint liability may be invoked when there are two or more than two people at fault. For example, आप किसी बस में जा रहे हो and आपकी बस का एक्सीडेंट हो जाता है because of the fault of your driver as well as the driver of the other vehicle. Now you have three options. Either you can sue the driver of your bus, you can sue the driver of the other bus, and you can sue both the drivers. So these drivers will be held jointly and severally responsible for the damages that they have caused to you. Jointly and severally का मतलब ये है कि इन दोनों की रिस्पॉन्सिबिलिटी बनती है, पर एट द सेम टाइम इनमें से एक एक की भी इक्वल रिस्पॉन्सिबिलिटी बनती है. An important thing to be noted in the concept of joint liability is that अगर आपने किसी एक जने को already sue कर दिया successfully for the damages that you are entitled to, आप दूसरे जने को for the same cause of action sue नहीं कर सकते हो. That is the concept of joint liability. Now let us move on to the concept of vicarious liability. Vicarious liability is founded in two Latin maxims. A, respondeat superior, which literally translates to let the superior respond, and B, qui facet alium facet per se, which translates to he who does the act through another is deemed in law to have done it himself. There are three elements which you need to take care of while establishing vicarious liability. One is that there should be some sort of relationship between you and the actor who has committed the tort. These relationships need to be of the nature of master-servant, principal-agent, director of a company and the company, partner or a firm, and other such relationships. The second element is that the nature of the work must be related to the relationship that you have with that person. For example, if your driver is driving the vehicle and he meets an accident, you will be held responsible for the damages that he has caused. However, if the chef is driving your car and he meets with an accident, then the relationship that you have with the chef is not of the nature of a driver. Therefore, you will not be held responsible for your chef's action. Now, the third element is that the actions should have been committed within the course of employment. Now, let's try and understand this with the help of an example. You have a friend who's working as a cashier at the bank and you want to get a certain amount of money deposited into your bank account. However, because you cannot go to the bank, you are unable to do it yourself. So you call your friend up, ask him to come down to your house and collect that money from you. But at a later stage you find out that उसने तो पैसा जमा करवाया ही नहीं है. And then you try and figure out whether the bank can be held responsible for the actions of your friend. The answer is no, the bank cannot be held responsible. The actions of your friend are strictly in a personal capacity and not pursuant to his employment at the bank. And therefore, the bank cannot be held responsible. In order to establish vicarious liability, it is important to establish all of these three elements. Now let us look at certain special circumstances which are extremely important from your CLAT preparations perspective. The first one is wrongful manner of doing an act. Now let's just assume कि कोई ट्रक ड्राइवर है जो कि एक पेट्रोल पंप पे पेट्रोल डिलीवरी करने जा रहा है and he lights up a cigarette, because of which an explosion happens. Now this is clearly a wrongful manner of doing a certain act, which is to deliver petrol. Can the employer of the driver in this case be held responsible vicariously for that explosion? The answer is yes. Wrongful manner of doing an act will also be covered within the bounds of vicarious liability. The second circumstance is willful wrong. Let's assume that your driver starts to race your cars with other drivers and meets with an accident. You will still be held responsible for his actions vicariously. The third circumstance is delegation of duty. Let's assume कि एक ड्राइवर है बस का जो कि बहुत थक गया है, तो he asks his conductor to drive the bus on his behalf. And while the conductor is driving the bus meets with an accident. The question is, क्या bus service company इस act के लिए liable होगी? The answer is yes. This will also be covered within the bounds of vicarious liability. The fourth circumstance is incidental act to an authorized act. Let's assume ड्राइवर आपके किसी काम से गया है and गाड़ी में पेट्रोल खत्म हो गया है. So he takes a detour to get the petrol filled. Now, while he's on his way to the petrol pump, he meets with an accident and causes certain damage to other person's car. Now in this case, you will still be held responsible for the compensation because filling up petrol is still incidental to the act that he's supposed to do, which is drive the car. The fifth circumstance is express prohibition. आपने अपने सर्वेंट्स को स्ट्रिक्टली इंस्ट्रक्ट किया हुआ है कि वो किसी तरह की एक्टिविटीज में इंडल्ज ना हो, बट वो स्टिल वो काम करते हैं. In this case, you will still be held responsible for the actions of your servant as long as they are within the course of employment. The sixth circumstance is lending of servants. For example, आपने अपने किसी सर्वेंट को किसी अपने दोस्त के भेज दिया है to get some work done, but वहां पे he commits a tort. Now, how will you determine whose liability will it be? Will it still be your liability to pay for the compensation, or will it be your friend's liability to pay for the compensation? In order to determine whose liability will it be, you need to take into account four factors. First one is who pays the servant while he is still there. The second one is how much control is your friend exercising over your servant. The third one is who can penalize the servant for his actions. The fourth one is whose machinery is it being used. Now let's assume that you send a crane and a driver to one of the construction sites and it causes an accident. Would it still be your responsibility to pay for the compensation? Indeed, yes, because the crane is yours, the driver is yours, as well as you have enough control over his actions. Another special circumstance in case of vicarious liability is the case of ratification. Ratification means that एक काम कोई already हो चुका है and आपने उसको बाद में authorize किया है. So, for example, आपका शेफ आपकी गाड़ी लेके बाजार जाता है सब्जी वगैरह खरीदने के लिए because घर में सब्जियां खत्म हो रही हैं and he didn't ask you. And while he's in the market, he meets with an accident. And now he comes home and tells you that he took your car and he met with an accident and you ratify that action. You said that okay, ठीक है, कोई बात नहीं. Now you will be held responsible to compensate for the actions of your chef, that is the accident caused, because you've ratified his actions and therefore you're vicariously liable. Another important aspect in case of vicarious liability is the case of an independent contractor. आप किसी भी independent contractor को तभी engage करते हो जब आपको उनसे एक particular task करवाना होता है, ना कि आपको उनकी services पूरे महीने के लिए या पूरे साल के लिए चाहिए होती है. So therefore, in order to establish the engagement of an independent contractor, you can look at the following elements. The first one is कि आप उनको तनख्वाह दे रहे हो या फिर आप उनको किसी एक पर्टिकुलर टास्क के लिए एक पर्टिकुलर अमाउंट दे रहे हो. Secondly, the amount of control that you exercise on that particular person. And generally, you would exercise lesser amount of control on an independent contractor. Thirdly, you can also apply the hire and fire test. For example, you hire a certain servant and if you dismiss them from the job, they will be rendered jobless. But that is not the case with an independent contractor. Because अगर आप किसी taxi driver को engage करते हो and you cancel the ride, it doesn't mean that the taxi driver no longer has an occupation. Fourthly, you can also look at the nature of work and how it is being done. Whether the person is bringing their own appliances and machinery is also an important factor to note. You're talking about independent contractors in case of vicarious liability because if you engage an independent contractor, you won't be held liable vicariously for their actions. For example, अगर आप किसी टैक्सी में जा रहे हो एंड उसका एक्सीडेंट हो जाता है तो आपकी रिस्पॉन्सिबिलिटी नहीं होती है उस एक्सीडेंट के लिए कॉम्पनसेट करने की. इट इज ओनली द टैक्सी ड्राइवर्स रिस्पॉन्सिबिलिटी टू पे फॉर कॉम्पनसेशन. नाउ लेट अस मूव ऑन टू द थर्ड concept for the day, that is strict liability. Strict liability may be invoked when certain precautionary measures are already taken. However, the incident still happens and the tortious act is committed. There are three elements which need to be established while arguing a case of strict liability. The first one is a dangerous thing or a non-natural use of land. For example, you can have a dangerous pet such as a snake at your home, or you can also have a poisonous plant. And a non-natural use of land would mean that you have a large body of water. The second element which needs to be established is the element of escape. Let's say tomorrow, if your snake leaves your house and bites another person, then it's a tortious act and you will be held strictly liable. Third element that you need to establish is mischief, that is a damage to the third person. It is to be noted that in case of strict liability, the compensation is directly proportional to the damage caused. Now coming to the next concept for the day, we have absolute liability. Absolute liability is an extension of the principles of strict liability. We have seen its application in the case of Oleum gas leak, Bhopal gas tragedy, and the recent Vizag gas leak. In order to establish a case of absolute liability, certain elements are needed to be established. That is A, The activity that the corporation or a person is engaging in is inherently dangerous. For example, in the Bhopal gas tragedy, the chemicals that the corporation was using were inherently dangerous to be stored within the premises of the city. B. All the possible damages that can accrue to anyone due to the inherently dangerous activity need to be compensated for. C. Escape, which is an inherent part of the concept of strict liability, is not required to be established in the case of an absolute liability. Even the workers which are working in factories engaged in inherently dangerous activities need to be compensated in case they have suffered a loss. I really hope that this session was informative and helpful to all of you guys. Don't forget to like, share and subscribe. Also, don't forget to follow our Instagram page because that is where you'll be getting all your updates.